what do you see, the two texts below that?
After her text?
No, your text, then she has two
Then
texts
she
here.
says, seems like no matter what I pay, you have more shit.
Okay, and then below that?
I want your bank and credit card statement since November.
Okay, and then what do you say?
From what cards and why? Only the B of A has been used, and I haven't used my Citibank in years, just paying it down now. The American Express has about 700 on it. PayPal I use for online buys only. I bought things for my kids on that.
Okay. So here she did ask you, did you produce those, all of your bank?
I just told her verbally. I didn't feel the need to like show her. To give her a printout. I just told her, or maybe showed her. I didn't feel the need to give her a printout or a document.
So this is all you produced, I guess. The text. In June of 2018, did you have a communication with Lindsay about her being on the deed?
I did.
And did she come to you?
She came to me.
Was she upset?
She did.
Was she upset?
She asked me, was she on the deed? I said, I called Wells Fargo to see if she was, and they told me she wasn't. And that was it. She was upset after she found out she wasn't.
Okay, so is that the first you learned as well, that she wasn't on the deed?
To my knowledge, that was so far in the back of my mind, I wasn't thinking about nothing like that.
Did that surprise you, that she was not on the deed?
Well, we were discussing divorce at that point, so I'm like, whatever, the house is going to have to go up for sale, and, you take whatever belongs to you, and I'll take whatever, and then that'll be it.
Prior to purchasing the home, when you discussed purchasing the home with her and making the investment, did she tell you that she wanted to be on the deed, that was important? Did you have that conversation with her?
I never said I didn't want her on a deed. It never really was a big topic about any deed.
You didn't discuss that with her before?
It wasn't, the house belonged to both of us. That was my knowledge, that this is our house. This is a house we produced for the marriage.
Okay.
I was never one time saying I'm gonna run off with the house and run off with your money. The money that you put involved into the marriage.
You looked at that as her money then?
Well, it became both of our money.
I have no further questions.
Your Honor, I would ask, is it your intention that we give closing arguments today? If I passed from doing a redirect and we went into it, would we be able to do a closing argument? Do it today?
If you do it now.
Okay. Then I've got no further questions for Bobby.
Okay. Okay, you can sit down. Sir. You can sit down. No further witnesses.
Mr. Jennings, did you want to admit 0079?
Yes, please.
Which document is that?
It's in Exhibit 6.
Everything's in Exhibit 6.
I know.
We should have just admitted the whole thing.
Was this proposed to be added as an exhibit?
I think you tried, but I interrupted.
Okay, I mean, I would object because it was entered in only through talking to Bobby about it. It wasn't presented to any other witness. It was only presented through Bobby, and this is a text message or conversation which Bobby doesn't participate.
it's been admitted into evidence and,
It has not been
it
admitted.
has not been admitted.
It's, 0079.
I think Linda referenced, it's all in the texts, all of her communications are in the texts as well, and her testimony. It's relevant for sure. It's relevant to the fact that it refreshed your client's recollection as to, you know, the money that had to come directly from the Chase account to go to the escrow closing, so it seems relevant.
Veracity was not determined through one of the parties on the message. It wasn't introduced through Linda. It wasn't introduced through Lindsay. It was attempted to be brought into Bobby, who isn't clearly stated as being on there. So it's attempting to introduce an exhibit through somebody that has no knowledge or no personal knowledge of its existence.
Your client he's in this text thread also.
I'm looking at the exhibit and I don't see it.
I can't see anything.
Yes, thank you, that's Bobby.
And we offered it, but then we started talking about the entire exhibit of 6. I said the entire exhibit of 6 wasn't admitted, and we changed subjects.
And this is the realtor.
And that's my understanding, is that it's between Lindsay and Linda.
No, it's all three of them, it's Lindsay, Bobby, and Linda. Because the top says, "Hi guys, I just got the signed contract," and then Bobby's next, "Yes, thank you." And then Linda's next. And
Still,
then Lindsay at the very bottom, "Okay." So all three of them.
I think it still lacks relevant and necessary details such as time and date.
I think it's very relevant. There was 2 checks cut for $3,000, one to Bobby and one to,
What witness did you get this in through?
Bobby.
You got it in
It was
through
used to
Bobby.
reflect his recollection on, did he receive the $3,000 check that he deposited in one Nevada account? Did he pay escrow, or then did they go back and ask Lindsay? Because we showed them that there was a check he received through the gift letters, or through the letters of explanation, where he did receive the $3,000 check. He had to explain that in his one Nevada account that was from Lindsay, and it was for escrow. But then we were showing that there was 2 checks cut because they said that they couldn't use that money given to him. He couldn't use that to pay for escrow. She had to cut another check that would go directly from her to the escrow account, or to escrow company, and that's what this text message was refresh his recollection, because he said, I don't know if I paid that or not, but then he stated after he read this text that that's what had to happen. The money had to come from the Chase account.
You know what, Honor, we're hurting for time. I'll agree to stipulate to it. We've already lost a lot of time today, and we don't have much remaining, so I'll stipulate to it if we can just get to closing arguments.
You have 10 minutes each.
Okay.
10 minutes.
10 minutes. Okay. Okay. Your Honor, Nevada Revised Statute, Section 123.130, states that all property of a spouse owned by him or her before marriage, and that was acquired by him or her afterwards by gift, bequest, devise, descended by an award for personal injury damages with the rents, issues and process of, is his or her separate property. We've established in this case that the plaintiff had sole and separate property in excess of $100,000 in her Chase account, and she also had approximately $26,100 of cash in her safe. That was her sole and separate property. The plaintiff then contributed a little under $75,000 from her personal and separate property accounts in the pursuit of purchasing a home to protect her financial estate. The evidence has established that the plaintiff paid off a debt on defendant's car to improve his debt ratio. She also gave him a check for $3,000 that was used for the earnest money deposit. The parties then learned that the $3,000 check was to come directly from Lindsay's account to the escrow title company, so a few days later she issued another check to the escrow title company directly for the earnest money deposit. The defendant never paid the $3,000 he received inadvertently back to the plaintiff. Then the plaintiff wired approximately $62,300 to the title escrow company prior to closing, in which the entire amount was earmarked to go towards the down payment and closing costs. It was later learned after the closing by the plaintiff that the defendant paid off approximately $8,374.03 of his student loan debt at the closing, utilizing these funds that were supposed to strictly go towards the purchase of the property. The plaintiff also handed over the defendant's $26,100 in cash that was to be held in custody by the defendant in his Goldman Sachs account to earn interest. This money was given to the defendant prior to the marriage. Not in contemplation of the community. They were not, said they were not romantic at that time until later. This money was to be held by him in custody to earn a higher interest rate on behalf of the plaintiff. By using his American Express card, there was no way for the plaintiff to know that he was actually spending her money. In fact, she believed that he was spending his own money on his American Express card. All the expenditures made on the Express card were believed to be, at his discretion, paid with his funds. Even the defendant's argument that he bought the plaintiff's wedding ring using her funds, and that she therefore benefited, is indefensible, as the plaintiff paid over $3,500 for his wedding ring from her funds. She shouldn't be required to pay for both of the parties' wedding rings. Moreover, if these funds were to be spent by the parties jointly, it begs the question why these funds weren't used to pay off the defendant's car, used for the earnest money deposit, or used towards the closing of the subject property, or why the plaintiff became irate with the defendant on their honeymoon in Cancun in February, when the defendant represented the plaintiff that he had spent the money on her, calling her a silly rabbit, but then still refused to show her his accounts. In all, the plaintiff contributed approximately $98,000, $98,421.82 from her sole and separate property, either to purchase the subject property or to have the defendant hold in his custody. In addition to the above items, the sole and separate property that needed to be accounted for and returned to the plaintiff, there's a few smaller items that the defendant still needs to be held accountable for. First, the defendant was ordered to keep the plaintiff on his health insurance policy by this court. However, when the plaintiff needed to receive medical treatment, she found that she was not on the policy. This caused her to incur a $1,700 medical expense. Next, in addition to, the plaintiff was although the plaintiff was the one that paid for the homeowner's insurance policy at closing and was assured that she would be added the title of the property and all the relevant accounts, when she had a $10,000 loss due to a theft from her automobile and went to make a claim, the insurance company told her that she was not on the policy or title to the property and that she was therefore not entitled to make a claim. Nevada Revised Statute 125.150, Section 2 states, if a party has made a contribution of separate property to the acquisition or improvement of property held in joint tenancy, the court may provide for the reimbursement of that party for his or her contribution. The amount of reimbursement must not exceed the amount of the contribution of separate property that can be traced to the acquisition. In determining whether to provide for reimbursement in whole or in part, a party who has contributed separate property, the court shall consider the intention of the parties in placing the property in joint tenancy, the length of the marriage, and any other factors the court deems relevant. In Szymanski versus Szymanski, the Nevada Supreme Court held that Nevada Revised Statute 125.150 does not irrevocably transmute separate property placed in a joint tenancy into community property. The plain language does not support a determination that separate property placed into joint tenancy is irrevocably transmuted into community property. It does not mandate that joint tenancy property be transmuted into community property, but only that it be disposed of in the same manner. In Lucchini versus Lucchini, the court stated the character of the property was established through the tracing of funds contained in 2 bank accounts that had been maintained throughout the marriage. It also states that the record reflects the thoroughness of which both parties' accounts reviewed the commingled funds and expenditures from both accounts, and even though some funds are unaccounted for, there exists substantial evidence to support the trial court's finding that the community and separate income and expenditures were traceable. Here in our case, Your Honor, these funds are absolutely traceable. There's no confusion about these funds not being traceable. Next, in Graham versus Graham, the court stated, a transfer of title from husband to wife creates a presumption of a gift. However, this presumption can be rebutted by clear and convincing evidence. The party wishes to overcome the presumption made use of by presenting substantial evidence of conduct, expressions, or intent at the time of taking or during the holding of the property. Here, the evidence is clear. The evidence has been presented in this case is clear and convincing that the plaintiff contributed her sole and separate property in the acquisition of the marital estate, and that she intended for the sole and separate property contributed to remain separate. From the early discussions with the defendant before their marriage related to protecting her funds by purchasing the real property, to communications with the realtor regarding her ability to review the closing documents before she wired the funds and signed the quitclaim deed at closing, to her overt actions of drafting an agreement, identifying her contribution, and getting defendant to agree to reimburse her the same upon the parties' divorce, and asking the defendant to sign said agreement prior to closing the transaction. This shows the intent of the plaintiff to maintain her contributed funds as sole and separate. In addition, it is also clear by the evidence that the plaintiff wanted to cancel the transaction until she was only willing to consider going forward, and that she was only willing to consider going forward after she could review the closing documents and to make sure that she would be on title to the property to protect her interest. The plaintiff has testified extensively that the quitclaim deed was forged to circumvent the stopgap she had thought was in place to ensure the property contribution was protected. Moreover, the party's real estate agent has confirmed that the plaintiff was not present during the signing and that she believed that both parties would be on the deed. The conduct of the parties and their intent in purchasing the marital residence is sufficient to rebut the presumption of any joint tenancy in the marital residence. There was no gift from plaintiff to defendant because the quitclaim deed was forged. Therefore, in addition, the intent by the agreement is clear. I'll skip 10 here because I'm short on time. Next, interpreting a contract, the court must effectuate the intent of the parties, which may be determined in light of surrounding circumstances if it's not clear from the contract itself. Here, the parties in this matter both produced two separate letter of agreements, one signed by each party and both dates January 17, 2018. The relevant provisions regarding the parties' distribution of assets and debts in agreement signed by Bobby states if divorce takes place, $75,000 is returned to Lindsay, Antee, and the remaining equity will be split 50-50. Her document adds one additional sentence in there, but it is superfluous if this court were to review it and doesn't really impact the overall intent of the party and should not, the agreement should still be looked at and considered binding upon the defendant. It's undisputed that the parties agreed that if the divorce takes place, $75,000 is returned to Lindsay and the remaining equity will be split 50-50. In closing, also, Your Honor, I just want to state that the plaintiff contributed 100% of the funds needed to acquire the subject real estate, pay off the car loans, pay off the student loans, all these things. The defendant did not contribute $1. And the plaintiff's contribution was not de minimis. Over $70,000 is not an immaterial contribution for real estate transaction in Clark County, especially when considering the percent the contribution constituted of the plaintiff's total estate prior to the marriage. These facts are even more significant when one takes into consideration that the plaintiff was only able to actually live in the home for a few months prior to filing for divorce. Therefore, to allow the defendant a complete windfall when he did not contribute any of his own funds in the acquisition of the property, and at the same time observing his behavior and kicking the plaintiff out of the home so she could not live there, and renting out the rooms to tenants and keeping the proceeds would be highly inequitable and constitute a manifest injustice to the plaintiff.
Thank you.
Thank you, Your Honor. This case is one of differences. And it's one of parties who apparently approached the idea and the concept of marriage very differently. One of the parties, Bobby, approached his marriage thinking that it was a community, which coincidentally coincides with the laws of Nevada. He believed that as they moved forward together, as they made decisions together as a married couple, that it was for the benefit of the community and that they would endure it together. Lindsay is attempting to say now that that was never her intention. That it was always her intention that everything of hers remained separate, that it never touched Bobby, or I guess involve him in any specific or real way. a main difference in this case, Your Honor, is that one party has relied on documents and the testimony of two credible witnesses. And that's Bobby. Bobby has presented documents and testimony showing that the parties began living together and began discussing a future together. They got married, and shortly after they got married, they got put onto a joint, or the plaintiff added Bobby to her account as a joint tenant, as a joint account. Schmansky v. Schmansky is very clear that separate property placed into joint tenancy is presumed to be a gift to the community unless overcome by clear and convincing evidence. Schmansky also goes on to state that the opinion of either spouse as to whether the property is separate or community is of no weight in determining its character. Essentially, the court has looked and said transmutation, what determines if transmutation has occurred is whether there has been some sort of action that shows an intent to transmute by the nature of the property. And that's from Stock Growers and Rancher Bank v. Milicic. Plaintiff took that action and took an action that showed an intent to place something into joint tenancy, which he did with these funds. Every fund that went towards this house came from an account that was in joint tenancy at the time. NRS 100 clearly states that if an account is intended to be held in joint tenancy, the account or proceeds from the account are owned by the persons named. Her very act of placing him onto these accounts was, as Schmansky anticipates, a gift to the community to be overcome only by clear and convincing evidence that wasn't the intention at the time. They haven't done it. They haven't reached that high bar of clear and convincing evidence. Another issue that requires clear and convincing evidence, Your Honor, is an accusation of fraud. The plaintiff has, throughout this case, very clear in police statements and otherwise, she has argued and put forth that my client fraudulently took her out of this sale. That he took her out of this purchase. The testimony and the documents show that that's not the case. Lindsay was a full and willing participant in the decision the community made, again, after the marriage, to pay off the debt remaining on the car. Again, a decision to sell the car that was made by the community. The community made the decision to pay off the student loans. They made the decision to pay off these other things that were necessary in order to purchase the house that the community wanted. It's also been made clear through testimony and documentation that this absolutely was a communal purchase. Because, as the plaintiff testified, there was no way she could obtain this house on her own. There is a real value to the credit that was provided by the defendant. And yes, these funds that were originally the plaintiff's that she placed into joint tenancy with the defendant were used towards the house, but it was only through the defendant's credit that they were able to purchase it. It was impossible otherwise. We talked about how the parties view the community and view marriage differently. In no way has the plaintiff come close to showing that this $26,000 that they accused my defendant of essentially stealing and using for his own personal purpose, they haven't showed even remotely that it wasn't used for community expenses. My clients provided documents that are in evidence that show the parties incurring great expense beyond just the wedding ring. I mean, let's talk about the wedding ring for a quick second. My client had $13,000 in his account before the marriage. The wedding ring cost $8,000. Yes, the plaintiff gave the defendant funds to put into the account, but there was still enough funds there to cover the purchase of the wedding ring. And so to claim that it was the defendant or the plaintiff's own money that was paying for it, it's ludicrous. Money's fungible. It was my client's funds that paid for the wedding ring. there has not been enough evidence presented by the plaintiff to show that this was some kind of fraudulent transaction in which she didn't participate. She had full participation, Your Honor. She signed the gift letters. She signed a quitclaim deed, which again, they're trying to claim was fraud. They haven't come close to meeting the clear and convincing evidence burden to show that it was fraud. As to the letters of agreement, a contract is no contract if it's brought about coercively. And there's no contract if there's never a firm meeting of the minds. At no point has a letter of agreement been produced that contains the same language and a signature by both parties. To say nothing of the fact that this essentially post-nuptial agreement was sent to my client while he was sitting at the title office when he already testified he had to leave after a short period of time to go to work. So she gave him no time, virtually no time to review this life-altering document before demanding that he sign it, or they would lose the house. That's coercive, Your Honor. She didn't give him an opportunity to review it with counsel. She didn't give him time necessary to review it. What I want to really point out that the evidence has shown, I mean, documentation shows all of the funds that my client paid for after the separation. Paid the mortgage, he paid the HOA, he paid $500 to her charity, he paid the sewage account. These are all there. The difference in these parties is that one party has repeatedly been caught making misrepresentations in this case, and it's not Bobby. Lindsay has misrepresented her earnings on her FDF by claiming she made no money in 2018 prior to September, when in fact she had made she'd made over $21,000 that year. She misrepresented her earnings to the IRS in 2017, which has resulted in the parties incurring a $10,000 tax liability. She misrepresented the conversations that she had with Linda Knott, claiming that she would never receive documents, which email clearly showed she had. She claimed that she never sent certain text messages to Bobby. Again, documentation showed that she had. One of these parties has provided credible, trustworthy testimony, and it's Bobby and Linda Knott, both of whom have testified that this was a joint venture, and that it was something that they did together as a community. The plaintiff can try to, I mean, so much of what was brought up in closing arguments has no factual basis other than the plaintiff's word. There's been no documents provided that the defendant cost her $10,000 in something that was stolen from her. She's provided no documentation showing that she incurred these medical expenses that were the fault of my client. None of these documents were provided. All that's been done is rely solely on the testimony of Lindsay Licari, which, as has been shown today and Friday, is not credible. The funds that went towards this house were community funds. They've been transmuted. The house should be sold. Parties should split equity, and then my client should receive the offsets that he's paid for pursuant to the order from the court from October of 18, and then also as justice requires. This is a case that never should have gotten this far up, Your Honor. It never should have come to trial, but it did because the plaintiff wanted a pound of flesh, and she was determined to take it however she could. The court shouldn't reward her for doing that.
Thank you. All right, we will be in recess, and you'll be receiving a written decision from the court. Thank you.
You know when we can expect that decision, Your Honor?
As soon as I'm able. As soon as I'm able.